Good evening, everyone. My name is Tanvi Dutt and I'm a registered migration agent here at Aussizz Group. Today's live session is going to be focused on partner visa. I'll be explaining you the whole procedure of the past partner visa, all the do's and don'ts, all the the checklist that is required, the whole process starting to the end, and the different types of partner visas that are there. So let's just start by saying that this is one of the most popular visas, which is nowadays being confused by the student dependent visa. Student dependent visa is a visa given to a spouse or the partner of the person who is coming with the student or with the applicant who is on a student visa, whereas the partner visa is a visa that is given to an applicant whose husband or wife or spouse is either a citizen of Australia, a permanent resident of Australia, or an eligible New Zealander. So now this is a very popular visa, as I mentioned, but at the same time it's not a very straightforward visa. You can't just log in and just lodge this visa. There are a lot of things that have to be looked into before we get this whole visa application prepared and lodged. So I'll start with the different types of visas. There are a few types of the partner visas. Now it all depends on your location, or by that what I mean is the location of the applicant and your personal your situation. So if you are engaged or you're married or you're in a de facto relationship, that is one factor that matters on which partner visa you are looking to apply. And then the second factor that actually affects this application is where is your partner based during the time of the application. We can start with the first type of visa, partner visa. It's called the Prospective Marriage Visa. Now this is a visa which is given to the applicants who are, in a simpler term we can say, who are engaged. So if you go to your home country, you get engaged to your soon to be wife or husband, you can come back and apply for a prospective marriage visa. Now this visa is given to your partner or the applicant to come to Australia. Now this is a visa for only 9 months, so they can get this visa for 9 months, which starts from the first entry date. So as soon as they arrive in Australia, you are required to get married within the 9 months of the time. Once you have that criteria ticked, then we can move on to the second stage of the partner visa, which I'll come to a little bit later. Now there are certain conditions that you have to meet for this particular visa, for the eligibility of this visa. The first and the foremost condition is that you have to have met in person. You can't have an online going online marriage fixed or just engagement, but basically you have to have met your partner in person at least once. That's the only way you can actually be eligible to apply for a prospective marriage visa. Also, you need to provide the proofs that you have been engaged or you are looking to get married in future. So things like your engagement photographs, your family affidavits, just that they are actually happy for you to get married. They've set a wedding or something like that. Now the processing time for this visa is usually between 12 months to 15 months because it's a lengthy process for all the partner visas. It's a lengthy process. This visa, like I mentioned, is granted for 9 months, and that starts from the first date of entry. Next, the good thing about this visa is that when your partner comes to Australia, even if you haven't got married so far, they will be allowed to work full time. They will be allowed multiple entries to Australia. So that means that within this 9 months period, they can go back to your home country and they can come back to Australia as many times as they like. But the only thing that they do not enjoy here in Australia would be the Medicare benefits. So you will have to have a private health insurance organized for them until they basically have the provisional the partner visa after you've gotten married. The next type of visa is the actual partner visa. Now this is basically divided into 2 steps. The first step is the provisional partner visa or the temporary partner visa, as we can call it, and then the second one is the permanent partner visa or the actual real partner visa, which allows a person to be a permanent resident of Australia. Now before I go ahead, the first visa that I mentioned was basically for the people who recently got engaged or who are looking to get engaged and looking to get their partner over and getting married here. This is for the people who are actually in a married relationship, which means that they've already gotten married, or they are in a de facto relationship. De facto relationship is more or less like a married relationship, but that you do not have a marriage certificate, which means that you haven't gotten married, but you are living together for 12 months, or you're sharing your life together for that long. Now, the first thing about this visa is that this is divided into two different types. One can be lodged when your partner is offshore, which is not in Australia, and then the other category of these visas can be applied when your partner is onshore, if they are on another visa. I'll get to the onshore one a little bit later. I'll start with the offshore application. Now this visa, the Provisional Partner Visa, the visa subclass is 309. Now for this visa you have to be married or in a de facto relationship, as I mentioned earlier, for at least 12 months. Your partner has to be overseas for this visa. They cannot be in Australia to be able to apply for 309. If they are in Australia, there's a different subclass that they need to lodge, but for this particular 309 they have to be overseas. Now this visa, the 309 visa, again the processing time for this visa is from 12 to 15 months. So what this visa does is that that when the person gets the Provisional Partner Visa, the 309, they can come and join their partner or the sponsor, as we call them in an immigration terminology. They will get the full work rights. They'll also get the multiple entry to Australia. Now the good thing about this visa is that they will also get the Medicare benefits. So if in case they need to use the medical facilities in Australia, that will be covered under Medicare for them if they get the 309 visa. The only thing that they'll be missing out on in this visa is some of the social welfares like Centrelink and other things. Whereas other than that, they will get all the benefits that a permanent resident in Australia will enjoy. Now, after you've been on the 309 visa for some time, you can lodge for the Permanent Partner Visa, which is a subclass 100. Now, subclass 100 is a Permanent Partner Visa subclass, and that can only be lodged from after the 2 years from the date of your 309's application. So, for example, if I lodged for a 309 visa today for myself, and I come to Australia to see my husband in 12 months' time, I would be allowed, or I would be eligible to apply for the Permanent Partner Visa 100 in another 12 months' time. So basically the term 2 years starts from the date of your first application, lodgement of your application date. Now this visa is a permanent visa. This lets you do everything any permanent resident in Australia would be allowed to do. This will also include some social benefits that they can get. There is a criteria that needs to be met to get all the social benefits, but that is the Centrelink side of the whole story that you have to clarify with your migration agent when you are in the situation. But whereas for the partner visa 100, that gives you all the rights other than just casting your vote in Australia. So more or less a permanent resident, this is what the permanent residency is for a partner visa 100. Now if your partner is onshore, for example, if say Mr. A is a citizen of Australia, he decides to marry a student, Miss B, who is a student in Australia, then in that case Miss B will lodge for a temporary partner visa or a provisional partner visa, but the subclass for this one would be 820. Now this is different from 309 only in a way that this is lodged onshore, whereas the 309 is lodged offshore, whereas other than that everything is more or less the same for this particular visa. The processing time would be the same, the fees would be same, everything would be same. The visa that an applicant can be on to be able to be eligible to apply for the 820 would be visas like student visa, visitor visa, working holiday visa, or even prospective marriage visa for that matter. When you apply for a provisional partner visa 820 onshore, what happens is that once your previous visa expires, you get a bridging visa A until your visa application is finalized. That means that until you're actually granted the 820 visa. So the whole the process time of 12 to 15 months, you will be on the bridging visa A. Now, with this particular visa, you will have the full work rights. Alright, and then eventually, once your 2 years time from the date of lodgement is complete, then you can lodge for the visa 801. Now, visa 801 is similar to visa 100, which is the permanent partner visa. The only difference, like I mentioned earlier, is that is lodged onshore, so the subclass is different. Now, there is one more thing in regards of the de facto. Like I mentioned earlier, that you have to be either in a married relationship or in a de facto relationship to be able to apply for a partner visa. The de facto relationship has to be going on for at least 12 months. That means you will have to be living together for 12 months, you will have to be sharing your life together for 12 months. For example, you can have a lease, you can rent a house together. You can mortgage. Obviously you wouldn't be allowed to buy a property, but if you're renting a house, the lease should be on both of yours name. That is one way you can actually prove that you've been living together for 1 year. Then you have to prove that your social aspect, that your friends can prove that you've been going out to you've been invited to the, say, weddings together, the parties, your birthday parties, friends, the celebrations of your cultural events. Everything is basically that you're going out as a couple. Another thing that makes it stronger would be if you have a joint bank account, or if you're sharing the financial responsibilities of the household itself. So there are certain things that you have to take care of to be able to meet the de facto relationship. So for that, it is better that you go and seek the expert advice, say a migration agent or some expert, to be able to see that you actually fall into the criteria of the de facto. Now, there is one way in which we can actually have this 12 months overruled or waived. In Australia itself, there is a way that the de facto partners can register their relationships in different states. Now, this is a different process in every state. New South Wales have a different type of process for registration of the relationship, Victoria, Queensland, so on and so forth. So, for example, New South Wales, for them the criteria for registration of the relationship is that you're not married and you have been living at least one of the partner has been living in New South Wales for a short period of time. Similarly, Victoria has the same criteria, whereas Queensland says that you're not married but one of the partner has been living in Queensland for at least 6 months. ACT requires you to be living there for a long period of time. One of the partners to be living in ACT for a longer period of time to be able to fall into the registration of relationship criteria. Now, if you have been married for more than 3 years, we would apply for the 309 or 820, which is the Provisional Partner Visa, but there is a higher chance that the Department of Immigration, rather than giving you the temporary or the Provisional Partner Visa, they'll straight away give you a Permanent Partner Visa. Because they're satisfied that you're in a genuine relationship, you've been together for 3 years or more, and if you have a child who is older than 2 years, that again strengthens your case, and then it makes it more likely for you to get a permanent partner visa rather than a temporary partner visa. Now, there are some conditions that have to be met when you're doing the partner visa application. First thing, especially when you're doing an onshore partner visa application, that is that there shouldn't be no further stay condition should not have been instated on the applicant's previous visa. So if the applicant, for example, is on a visitor visa in Australia and then they decide to get married to an Australian resident, they have to make sure that they do not have a no further stay condition put on their visitor visa. If that's the case, then there is a process that you can request a waiver, but there's a higher chance that you do not get a waiver of that condition. So you might have to go offshore and then apply for the 309, which is the offshore provisional partner visa. Now, again, like I mentioned, you have to be either married or in a de facto relationship for 12 months unless your relationship is registered in the state. Now, you also have to provide the evidence of genuineness and the ongoing relationship, which can, first thing would be marriage certificate. Like I mentioned, you can have the shared life, like the lease and the mortgage and other things together. You buying things together in joint names, your financial commitment, your banking, you're spending money for the household. Both of you are doing it together. Your social aspect proves that you're in a genuine relationship, that you're going out together, you're watching movies together, you're going out for dinners, you're being invited as a couple to the weddings and the birthday parties, etc. The genuineness of the relationship is the most important factor that has to be proved to the case officer, because this is the main factor on the basis of which most of the partner visas get refused. So this has to be made in a very strong way so that your application is accepted at the first go. The reason I'm saying that, because there is a fee. This is a very expensive visa. There's a fee associated with, obviously there is a fee associated with every visa, but this is in particular a very expensive visa. The fee associated with any one of these partner visas is $7,000 for the base applicant. That means the spouse. And if that spouse has a dependent child of over 18 years of age, then that would be an additional $3,505. Or else if they have a dependent child under 18 years of age, it's $1,755 on the top of the base application. Now these dependent children can also be their children from the previous marriage or their children from the current relationship with the sponsor. There is a very important document that needs to be attached along with your application. Now that is called a form Triplet. Form Triplet is basically a form which is completed by an Australian resident or an Australian citizen, and that actually proves that they are explaining in that form that you have been in a genuine relationship, that you're in a married relationship, and they can justify their legal status in Australia. So if they are an Australian citizen, they can prove that with the copy of their passport or their citizenship certificate, or if they are a permanent resident, they can prove that with the stamp or the label of the permanent residency. So this form has to be filled by two people, two Australian residents or citizens. Now this forms a very important part of your partner visa application. Now there are certain situations where this is not as straightforward as it seems. For example, let's take a scenario where somebody has come to Australia and they have not been able to maintain a lawful status in Australia. That means they are not on a legal visa. They are not on any visa, I would say, in that matter. So their visas have expired or refused or cancelled, and they haven't been able to report that to the department within 30 days or the 12 months period. So that in that case, there is a criteria that is imposed on those applicants that is called a Schedule 3 criteria. Now Schedule 3 criteria is where the Department of Immigration is going to ask the applicant, why do you have to apply for this visa onshore? Why can't you go offshore? Why can't you go back to your home country and then apply for a partner visa? So for that, there has to be a very strong application put on. We've recently had a case where Schedule 3 criteria was implied on one of the applicants. So he had to justify that. One of the reasons that he got his Schedule 3 waiver, that means the Schedule 3 criteria was removed from his application, was that they had a child together and then the child was school age. So they had proved that if the child would go back to the home country, that the child would miss out on the wonderful education system that Australia provides. So which means that the child was going to miss out on the quality education, and then it was difficult for the child to settle in the new country and then again come back to Australia. So on the basis of that, the Schedule 3 criteria, which means that he was requested to leave Australia to make an application, was waived on his application, and he could make his partner visa application in Australia while living in Australia. Now so by the looks of it, what we have to do is that we have to prove that you have a very compelling and a compassionate circumstance to not have to leave the country and to make the application here. So that could be anything from an illness, of your partner. It could be an emotional distress, it could be a child's schooling, it could also be financial support for your partner. It could be a possibility that your spouse or the sponsor is not working currently, and then they would suffer financially. So that could be one of the reasons we could actually request for a waiver of this Schedule 3 criteria condition. Now this is something that has to be definitely dealt by an expert, so I would highly encourage you to seek the advice of an expert migration agent. You can come to us and get your case assessed, and then you can thereon and therefore decide what you want to do from there on. And then make an application, make a strong application in the first go. Because you have to keep in mind that the application, once it's submitted, the fees that you've sent to the Department of Immigration, they are non-refundable. So the $7,000 or even more, if you put in towards this application and you haven't made that application correctly, will never be refunded back to you in case your application was incorrectly filled in or it was incomplete application. Now, having said that, there's been a recent change that has happened in an application process of a partner visa. Initially or earlier, they could also make a paper-based application. You could print the form of the computer and then you could fill the application by hand. But that thing has been removed now, so your partner visa application has to be made online. So make sure that you do not send to the Department of Immigration an application which is printed and handwritten or even hand printed. So it has to be an online application made through your account. That is the only acceptable application which the department is going to take up. Now there are certain things that you need to know in regards with this visa. They're like the summarized points that I would like to mention before I finish this session. There could be an interview organized by the case officer. Now this depends whether or not you get an interview. It depends on the case officer and how strong your file is. So they could actually request an interview. Now this interview could be a phone-based interview or it could be a face-to-face interview. So your partner, if they're offshore, they could be requested to go to the Australian embassy in their country, or if they are here in Australia, they could go to the Australian the immigration office, whichever state they're in. So every state in Australia, their capital cities have the office. So mainly Sydney, Melbourne, these are the main ones, and then the other ones also have the immigration offices. Now that can be organized by the case officer. The second thing is that you have to be living together and not be apart for too long, until and unless, like I earlier mentioned, there are compelling circumstances for you or a strong reason for you to be living separately. It could be a job, it could be a health issue or something like that, but you have to make sure that you can actually prove that in documentation so that the Department of Immigration gets an evidence and then they understand why you're living separately. There is another thing that there are certain instances where the age of the couple, the age gap of the couple is quite a lot. So usually you would want to get married to the person who is more or less the same age as you, like 5 or 10 years here and there. But there are some times where the age gap is around 20, 30, 40 years, sometimes even a little bit more. There rarely are cases like that, but these cases absolutely are acceptable. There is no reason that Department of Immigration does not accept you as a genuine couple until and unless you are not a genuine couple. By what I mean is that if you are basically just basing your marriage just for the purpose of getting the immigration status here in Australia and you cannot prove the genuineness of the marriage, the case officers have a lot of ways to find out. They have different teams in this particular visa who are looking into your application very thoroughly, and they are going to make sure that they check each and every avenue to be sure that you are a genuine couple. So even if your age gap is a lot and you're still a genuine couple, and you can actually prove that by for example your Facebook posts, your pictures, you're going out together, you're living together and things like that, then that is absolutely acceptable by the Department of Immigration. Another thing is that you have to, like I mentioned, you have to prove that your relationship is ongoing. So which means is that if in case you got married, you came to Australia on a temporary partner visa or provisional partner visa, but you're not together anymore, and that can be an issue if you can't prove that your relationship is not ongoing. So if your relationship is not ongoing, it is your responsibility to inform the Department of Immigration of this change, but you have to make sure that your relationship is ongoing to get the permanent partner visa thereon. Marriage certificate. I know that marriage certificate is one of the most important documents when you get married to prove that you guys are a couple. You are actually in a married relationship, but it is not enough. Marriage certificate is one of the document that is attached to the application, but that is not the only document attached to the application. So please make sure that you do not make a mistake by thinking that you have a marriage certificate, you can make an application and not put anything else. That is absolutely going to get you a refusal. There is one more thing. If you have a child together, that is one thing, but if you intending to intentionally get pregnant for the purpose of getting a partner visa, that cannot strengthen your case. So you have to make sure that your relationship is genuine. Obviously you will have your family later on, but even if you're having your family now, the relationship still has to be genuine, but this cannot be one reason to strengthen your case or fast track your case. This is a very important point which I would like to mention, and I would like all of you to note. For all the sponsors who are in Australia who are looking to get their partners over to Australia, you are only allowed to sponsor twice in your lifetime. So if you get married and God forbid your partner, when they come here, you do not get along and you decide to go your separate ways, you will have to wait for at least 5 years. You will have to wait for the 5 years from the date of the application lodgement, the first date of the application lodgement of your partner's provisional partner visa, to make the other application for the new partner that you decide to marry later on. So there are times when you can actually have that waived, unless so again the compelling and compassionate circumstances are there. You can prove that there was a compelling reason why you decided to go your separate ways, and why should you be given more than 2 chances to have your partner over to Australia. But that is very difficult to get, so make sure that you are very thorough and very particular about the fact that you choose the right person to come over. Don't take this visa lightly, and don't think that you're just going to get somebody over for the purpose of visa, because there could be a possibility later in your life that you would genuinely want to get your partner here and you missed out that chance. Then there's another thing that I'd like to mention, that the main reason for the refusal of these visas is the genuineness. If you cannot prove the genuineness of your relationship, then they're absolutely going to refuse your visa. They would not go on assumptions. By they I mean the case officers. They would not go on the assumptions. They would have to have a hard proof to prove. They have to have photographs. They have to have your social media accounts, your utility bills, your other documentation that can actually proving the fact that you have been living together for all that long, and you having an ongoing genuine relationship. There are a lot of refusals happening on the basis of the genuineness of the relationship. So make sure you put a strong file with all the documents, and then you make sure you keep a track of your application, and it is your responsibility to let your migration agent know, to get the department the information if there is any change in your circumstance. If you are going your separate ways, if you are having a child, or if there is any other change in your application that needs to be notified to the department, you have to make sure that is done on time, because it is your responsibility. Later on that can actually weaken your case if you don't do that. Once this application is put through, I know that there is a lot of wait for this visa. So 12 to 15 months, you would not want to wait 12 to 15 months to be reunited with your partner. And for you to be leaving your job and then going back to see your partner, I understand that is a little bit harder. So what can be done in this scenario is, once you've lodged your partner's offshore provisional partner visa application, you can make a visitor visa application. But I always encourage the clients to do that after they've lodged their partner visa application, in order to, if in case they are looking to lodge a visitor visa application. Because if your visitor visa application is lodged before your partner visa application, A, you're losing time, and B, if it is refused, that goes into your immigration history, and refusal is something that kind of weakens your case. It doesn't strengthen your case. So after you've lodged your temporary partner visa application, or your partner visa application process is started, after that you can lodge a visitor visa application to have your partner come over and join you. So these are basically all the things that I would like to mention today. If you have any questions, anything, any comments, please leave them in the comments below. and I will get back to you. I'll answer those questions. You can come to us here at Aussizz in our office in Melbourne, Sydney. We've got our offices at a lot of places. You can actually get the addresses of our Facebook. You can get them off our website. You can see us and you can get your case assessed by one of our expert migration agents, and we can go from there. Thank you.